We'd like to acknowledge the traditional custodians of the land from which we broadcast today and acknowledge their elders, past, present, and emerging. Hi, everybody. This is Paula. This show is not about legal advice. It's really just about our experiences going through the process in the family law courts, what can work, what doesn't work, what's for you to consider to try. And it's just about the process, giving you some familiarity with it, and hope that gives you a little bit of a help.
You're listening to a Mel and Kim Productions podcast. What happens when a lawyer and a family mediator step into a bar? Join us to find out. Diane and Paula have real conversations about the family law process in Australia. Whether you're a part of the family law system or about to engage in the process, find out what the realities versus perceptions are. Diane and Paula don't hold back on their individual perspectives and experiences.
Welcome back, everybody, to a lawyer and a mediator walk into a bar. I'm Diane Loveday, and this is my colleague and friend,
Paul Applehans. Thanks for joining us.
Thank you for joining us. Today we want to discuss discovery.
Discovery, disclosure, handing up stuff.
Yeah.
Sharing stuff.
Sharing, yes. And sharing stuff with somebody you might not necessarily want to share the stuff with.
Oh, there's lots of stuff you don't want to share.
Yeah, I know, but you got to.
You have to.
You got to. You got to. There's a thing called full and frank disclosure.
Yeah, and you know what? It sounds like it's, full and frank disclosure. Yeah. It's so real. It's so very real that when you don't do it, it's something very contrary to your own efforts, is what I try to tell folks.
Okay.
So, but discovery and disclosure, again, in mediation versus the legal format. So I'm going to let you start with, because you start a lot of things off, honestly, when you go into family dispute resolution.
Yeah, and our process, again, is quite different. And it's quite different because I'm not a lawyer. And even if I was a lawyer, I'm not acting as a lawyer. I'm acting as a family dispute resolution practitioner. So I don't have the same requirements. And how I explain it to my clients is I explain that there is a requirement for full and frank disclosure, which means, if you have your overseas bank account, now's the time to tell me about it.
Overseas property.
Yeah, anything. And because ours is a mediation process, I also get minutiae. I talk about boys' toys. I talk about jewellery. I talk about everything, because when you understand the mediation process, you want to give them something to agree on first.
Give them the bits that are agreeable.
Yeah, exactly. And then you build up to the big things. But when I'm talking about discovery with a financial or a property mediation, and I explain that for what discovery, because I'm not a lawyer, I don't have the same obligations that a lawyer has. I'm never going to be standing in front of a judge being asked why have I given the advice I've given, because I don't give advice.
Correct.
I'm managing a process for you to come up with your own agreement, you being the clients. So discovery is at your discretion. So you provide the discovery or ask for the discovery you feel is relevant. So if you want 3 years of bank statements, you have to ask for it. Vast majority of our clients have joint bank accounts, have joint everything. They know the ins and outs of everybody's business. So for them, providing years of bank statements, mortgages statements, credit card statements is onerous and unnecessary.
Because they've been through, they're seeing it as, they're very aware. They were part of the process. They were part of being of the one charging and looking at statements and
being involved with the relationship.
Do you find that more often than not now, or do you find it less and less?
I often make a joke that I think I'll have do a PhD on number of clients who come through who had separate bank accounts as opposed to the ones who had joint bank accounts, because there are more people coming through with separate bank accounts. But still people are across what each other earns, what each other is spending, where money is coming and going.
So they already have at least some sort of center of trust that says, as far as I know, he hasn't done anything outside. Yeah. I would have seen the money go somewhere else. Or I would have questioned. I would have been that involved already. Yes. So I don't need to go back 3 years. Place and time right now is good.
Yep.
Yeah.
And so reaching agreement on the value of things, and again, we don't need formal valuations. We simply need cars.com,
The Red Book or even
whatever.
Like,
yeah. Three real estate agent valuations is enough for the conversation and the negotiation. So our requirement for discovery is at the client's discretion. Now, I have had situations, because I hear both sides of the story, where I have known that there is money that the other party didn't know about, which puts me in a really...
I was going to ask, because, you knowing something and the other side not knowing, how do you resolve?
What I try and do is encourage the party who is being kept in the dark to ask for disclosure, to ask for information without, because remember, I cannot divulge the information because it's completely confidential. So I'm encouraging them that maybe they should seek some legal advice if you haven't already done it, or maybe ask for some bank accounts and just take the time and go through them and just have a look what's going on. I can encourage till I'm blue in the face, but if they are comfortable and don't want to, it's not my decision. And so, if it were, and here I'm making a value judgment in my own head, I'm not liking it, but
I think we do that a lot.
I know, happens a lot. If I felt there was a huge discrepancy and it was a real issue, we would refuse to continue with the process.
Okay, so that's your resolve.
Yeah.
Is that if it's that disparate or this that much of a disparity?
Yeah, and we have done that in the past. We have said, look, no, sorry, we won't. And we can't tell you why. Sorry, go off, talk to lawyers. But there are instances where it's both parties are really satisfied with the outcome, despite us knowing that there might be a little bit of a difference that.
Well, and that's a really good point, in that sometimes you're just done.
Yeah.
And, if there's a 5% quibble back and forth and you're just ready to walk, there is value in that. And I try to tell folks that too. That there is a value that,
that makes me feel better.
But I mean, there is.
Yeah.
I mean, I'm not going to lie. I have been divorced twice. I'm going to throw that out there. Been a member of the club twice. And at that point, you're like, you know what? I'm okay. Yeah. If I have to take on more of the debt or take on less of the asset or whatever there is, and I can just breathe again.
Yeah.
I can sleep at night.
Oh,
I'm not, I can't tell you what that value is. And I can't tell other people what that value is, but I do address it as saying there is a value there.
Yeah.
You
absolutely.
decide. But if you're good with a 65, 35, whatever the split is, and you can walk away, I'm not going to tell you different. I just have to advise you that this is the split. I think that maybe there is some value in doing something else. But if you decide there's more value in closing this and resolving this and walking away, you've at least been advised.
Yep.
And walk away.
Yeah.
Do that.
Yep.
Clean your hands.
It's a big
blackjack hands. All good.
That's such a big conversation that we have with what's it worth to be able to put this to bed and walk away?
Yeah.
Because yes, you might get 5% more if you go down the discovery path with lawyers, or there may be something you don't know about, or something. There was a really interesting case written up in a law journal a few years ago now, where a couple had gone through mediation and reached agreement. One party had accepted the other party's valuations on quite a lot of properties, and had also accepted an accountant's valuation on a business that was supposedly running at a loss, and they settled. Within 12 months, the other party noticed that one of the properties sold for like 5 times what had been valued at, and the business started turning over millions.
Overnight, I bet.
Overnight.
Yes, exactly. Quite contemporaneously to the signing.
So she took the matter back to court and was awarded a more fair, a more just and equitable disbursement of their
There we
pool.
go. Just and equitable. That's a key term.
Yeah. So she was awarded a greater percentage, and he took it to the Supreme Court, where the judge there called this a gross miscarriage of justice, which I love that term.
Well, because he failed to disclose.
Exactly. Yeah. And it basically manipulated the system and her goodwill. And that, I think, is apprehensible.
It is. And here he was for 12 months thinking he got away with it.
Yes.
So why didn't he feel good about it?
Because he ended up having to pay her legal costs as well.
Yeah. Until you had to pay legal costs, you know.
Yeah.
But the whole point was his failure. It wasn't just a failure to disclose, because he did disclose. What he didn't do was do it at a fair market or a fair value.
Yeah.
So anything, again, fair and equitable.
Yes.
Just you just want something that says, you know what, we may have had this, and what did he do? Did he have 3 real estate agents on the payroll or something? I mean, how did he get other professionals to agree?
I don't know.
That'd be something to go look up.
Yeah.
But I guess that's the really important thing, is there's a way to disclose, and there are consequences.
Yes.
So not just failing to disclose, but disclosing inappropriately, I guess, would be that case.
Yes.
You could say that you've done these things and everything's up and up, and everybody in the system trusted that. But it doesn't. I guess people need to understand that even if you get that agreement, there are ways that agreement's not valid.
Yeah.
Voidable, how you want to put legalese to it. But you can come back and say, look, he didn't disclose appropriately, or he manipulated things until it was over. And
the problem with coming back is always the cost.
Always
the cost.
It's always going to cost more to come back.
Yeah. Well, you've got to seek permission from the court to start with to be able to.
Yeah, especially if it's a final order.
Yeah.
But exactly. So so the entire purpose here is, and especially disclosure in family dispute resolution. It's a broad net.
Mm-hmm.
You try to get, a lot of it's based on trust. If there's no trust to begin with, then you're going to look at this probably and say, oh, we're going to have to issue a certificate.
Yeah.
But you've gone through, because now I guess process-wise, you go through where you talk to each side separately.
Mm-hmm. Yep.
You do the pre-interviews or whatever. Yep. And then both sides give you an idea of what they're looking at and what they're looking for.
Yeah, we take out what I call it a bit of a mud map, a list of assets and liabilities at the intake interview at the
That's at the intake interview, right. So you're getting everybody properly prepared as well.
Yeah, so I got an idea of what this pool is worth. I also have a conversation about what do you want to achieve out of it. But I also run through the 4 guiding principles to make sure they have an understanding of what their obligations are as far as the law is concerned, because we may be mediation, but the agreement still has to comply with the Act.
There you go.
Yes.
I think maybe that helps lawyers understand sometimes.
Yeah.
Because sometimes like, oh, I've got to go through the dispute resolution. Well, there are guidelines, any way you look at it. And as far as obtaining the information, now, again, yours is a little more, I'm going to say, open about the process, a little more open. But, there are still the guiding principles.
Yes.
And I think that's what people really need to hear as well.
Sorry, I'm moving down a slightly different path, because I do know that there are FDRs, people with my qualification, who don't actually understand about the guiding principles.
What?
I know. I know. Because it's just not taught in the qualification.
Okay, that's news to me.
Yeah.
Anyway.
And which is why it's important when people are looking for somebody to help them with a financial settlement, and if they want to do mediation first, to make sure that the company they pick or the person they pick has experience working with financial settlements.
Yeah, because some of these, and it may sound silly or it may sound simple, but there are a lot of families that maybe just have, even if they just have 2 properties, they don't have a family trust. Maybe they do.
Mm-hmm.
There's all sorts of mechanisms. And it doesn't have to be millionaires that do these things.
Oh,
no. And most of them aren't any.
No.
I mean,
but a big part of the intake interview for us is also with a property matter is to determine whether it's out of our pay league. If it's too complicated, there's too many shelf companies and trusts, and there's a personal trust and a business trust, and there's all and then it's sorry. no, we can't do this for you. You need to find yourself. I can point you in the direction of some good lawyers, but no. Or we can help you negotiate and bring lawyers to the process.
I think that was where I was getting to, is that even if you handle the process, there is the option for lawyer attendance.
Oh, absolutely. Yeah.
And talk about that for a second, though,
Okay.
because
with property matters, I don't see the necessity for lawyers with children's matters predominantly, because ultimately what I'm trying to do is help parents learn how to be good co-parents. So helping them with boundaries and procedures and communication strategies to get beyond the angst that they're feeling right now and majority of lawyers aren't particularly useful at that process.
I'll let you have that one.
Thank you. But property, absolutely. Property is the law and facts and figures, numbers.
Yep.
And that's what it is. So if our process isn't successful, and I always suggest to people, try us first, try and reach your own agreement. But if that doesn't pan out, that's fine. Then your options are go lawyer up, or we can bring lawyers into the space. And then you can have the conversations with your lawyers present, so you're getting legal advice, which is what I can't give you.
Right. But there is the ability to do that. I don't think a lot of folks understand that there is that potential as well. And especially, like you say, on property matters, sometimes it's just coming down to do they own the property as tenants in common versus joint tenants? Do they own the property as part of a family trust? I mean, those are all legal aspects, but they don't have to define how the property gets settled in some ways. Again, if you're in agreement on something, she has that property, I take that property, there we go.
Yeah. As long as we take into account the capital gains, potential capital gains.
There's a sticky wicket.
Yeah.
But again, the whole point here is that, family dispute resolution has value. It has options. If we can, if you can't decide it equally, maybe try bringing the lawyers into that process.
Yes.
You can always go back to lawyers. I'm always the fallback. I'm good with that. Again, the more you guys can resolve, the more people feel like they have come to a resolution.
Yeah.
And it may sound crazy, but they also feel like they've had a little bit more say and control of the situation.
So our process with property matters is we run people through the 4 guiding principles and we write it all up. We have electronic whiteboards. So, the 4 guiding principles, what are the assets and liabilities? What are the contributions? What are the future needs? And is it a just and equitable disbursement of the available pool? So we write up the assets and liabilities on the whiteboard, print that off. They both get a copy. We write up all the contributions. Who's contributed what? We talk about the story of your life, your relationship. This is what has to go into the documents if we get to the point where we're filling in consent orders. Then we look at future needs. How is that all going to pan out? What are you planning? Who's looking after the kids majority of the time? Who earns what? Health of both parties, ages of both parties, all these considerations that have to be taken into account. And we print that off and we give them that. And then we get to the nuts and bolts bit. And if they can't reach an agreement, that's fine. They've got the same story.
Yeah.
That they can then take to their lawyers and say, well, this is what we've agreed on. What do you think?
And here's where we haven't agreed.
Yes, exactly.
I find such a value in that process alone because, again, part of that helps diffuse the emotion. It helps diffuse the back and forth, the antagonism.
Yeah.
Something, and the fact that you put it on paper, people are like, okay, it's that whole visual.
Yeah.
It's the optics. Is it as much as I thought it was? Oh, I thought it would have been more. Maybe it is more. Maybe it isn't. But at least you have a starting premise.
Yes.
To work from. And that helps, again, refocus from all the, I did all this while he did that and she did that and he said, she said. And
I know who you're talking about now. Yeah.
He didn't do anything. I carried the baby for,
That's actually relevant. And we do have that conversation. Your lawyer isn't interested in how that made you feel.
But you can have that discussion as to how that is going to wrap around the visual of the actual assets and liabilities. Because everybody, and I have to have that conversation too, especially if they haven't gone through the process. We start over with, again, assets and liabilities. Well, I didn't realize it was that much. It was like, well, here's your where's your last statement? Oh, you showed me your last statement. Well, that's what it says.
Yes.
So again, sometimes it's just about, these aren't props, these are visuals. These are the optics. So if you take away the mortgage from the asset, it doesn't matter what you think it is. Here's your reality check.
Yeah, this is what it's worth. This is what you're going to get. And this is,
So let's start talking. And I tell folks, it's, we can talk all we want about future needs and the contributions. To me, that's a separate, but we have to establish what I call the realities first.
And that's the difference with the lawyer discovery, because it's a much more in-depth conversation. And
it is.
Yeah.
But again, if you can narrow it down, you can, it's amazing how much putting something on paper diffuses the antagonism.
Yeah.
Now, there's going to be that percentage where it increases it. Absolutely. Because there are going to be people who are like, when they look at something and they fall apart. But at the same time, it does give you a better footing.
Yeah. And
when they come to me, and we can start with the premise, they've already had the minute to look at it. They've already had the moments to put it in their head as to, and they may come to me, slam the paper in front of my face and say, this can't be right. And I'm like, okay, where's it wrong? So then I was like, show me. Yeah, I'm all about the evidence at this point. It's like, show me the paper, show me the documents. Well, this is what he said. Well, yeah. Where did he back that up with? So we go into a deeper dive. Yes. Absolutely. Yeah. But at the same time, you're right. In some ways, I'm not going to listen to the story as much as probably they would like me to.
Yeah.
Honestly, that eats up time. That time is money. And by the time you get to me, and you've gone through the process, which is why I like it when they go through the family dispute process, whether it's children or property settlement. If they have at least attempted the process and gone through a day of mediation or half a day, gotten somewhere with it with you, then they've at least identified the four guiding principles. They may not understand it to the nth degree. They're not supposed to. They're not going to. I wouldn't want them to. Again, it's one of those. It's one of those things where it's a must do, have to. Don't like to, but there you go.
But I find with our process, it really does help because we get so many people who have expectations about they come to our process thinking it's a soft option, and that
I wouldn't call it a soft option,
but they have
the perception, right?
It's a perception. It's a perception and that this is what I want. So can you get this done for me? Type notion, the super is mine. Mine. Yeah,
exactly.
I've earned all the money.
Yeah, they never did anything. That's not how it works.
Yeah, it's not how it works. So I find taking them through the four guiding principles helps de-escalate the sense of entitlement.
That's the way to put it.
Yes.
Because there are things you are entitled to.
Yes.
As a breakup of a relationship. There are things, and entitlement does play a part.
Yep.
But there comes a point in that reality check where entitlement is the pie in the sky.
Yeah.
And it's like, well, we have to bring you back down.
Mm-hmm.
So managing expectations. And don't be mad at me, but if you get the brunt of it at first, I'm good with that.
That's fine.
I'm good with that. Let you take the brunt of it. It gets measured back down to me. Maybe they've reincited their entitlement expectations, and I have to reset it again. But that wouldn't be brand new. It would just be a continuation from what has already happened.
I do say to clients, vent on me. I'm cheaper.
You are cheaper for venting. That's for sure.
Exactly. And, why would you guys?
Unfortunately, I've gotten to the point where, I did early on, I used to let folks just vent because, it is a process.
Mm-hmm.
This is a process. And sometimes you've got to get that out in order for your client to recalibrate, reset. But there are also times it's like, that's not part of the story. I actually have had, especially in the past year, I've had to have quite a few conference calls with clients that is like, there's the legal side, then there's the equitable side, and then there's the unicorn and fairy floss side. So I need to move you from unicorns and fairy floss over to the legal, and then maybe we can chat about the equitable. Yeah. So I'm trying to. So and it sounds bad, but once they've been introduced to the concept, I'm like unicorns and fairy floss. They keep going unicorns and fairy floss. So
I love that.
I want unicorns and fairy floss too. Trust me.
Yeah, it doesn't.
We all do. We all do. But then we have to get back to what's the real discussion. Let's get it back on track. Let's move it back over to where we need to. Then let's see where we can get to.
Yeah. So with your discovery.
Oh, what we
disclosure.
do. Yeah. Again, we go into that deeper set of full and frank.
Yes.
Full and frank. That almost sounds like, I won't go there. It sounds like an enforcement team. Full and frank. And in some ways, maybe it should be thought of as a an enforcement team, because when it comes to our level, again, at this point, we've got usually two solicitors involved. Mm-hmm. We have duties to the court, duties to the client. These are things that we really can't fudge on.
No,
we can't. And there are times people say, "Well, what about this?" I can't do that. I'm very short and blunt to the point where like, no, that's a no. Let's see, we'll do the next step. And then we go but then we can have some enforcement values. So the court does give us some options for enforcement. There's the contravention list. He hasn't done this, this, and this. Mm-hmm. We've advised his counsel and his solicitor. We've talked to the other side. We've given them several letters demanding this, and this because they are relevant. We've explained why they're relevant, and still no movement. We can either go back to the contraventions list where they have the ability to go into more depth. They can fine you with civil penalties. They can even throw you in jail for failure to comply.
Does that happen?
Well, I just read a case where a guy was thrown.
Really?
He appealed it, and there were some issues with the appeal as to why what he was actually found to be in contempt of. Turns out he wasn't found in contempt of. So the other judge who got the case did put him into prison. Turns out there was no real contempt charge, that he was actually, long story short, can it happen? Absolutely. Does the contravention list judge have that discretion? Guess what? They do.
Right.
So again, it's building your evidence that says you've asked. Mm. Then you have a subpoena process.
Yeah.
So there are some legal mechanisms that we can go back after some of these things. But the consequences at that point are a little more dire. So that if you fail to disclose and the other side finds that, which you were trying to hide, the court can come back at you and say, you know what, your argument's gone. You don't get that you don't get to include, that money goes to this side already. I mean, there's, different things that the court can actually come back with as a consequence. And, that's going to be harder to fight.
I'm sitting here a little bit gobsmacked because you don't hear about those sorts of things happening all that often.
Usually it's a civil penalty. They haven't done it. There's a snap, smack on the head, wrist, and here's you got to do it. And then the solicitor gets involved and starts really reinforcing that you need to do, which I'm sure they did already. But now the court says, and you can tell your client, I told you if you didn't do this, this is what's going to happen. Yeah. Now you get costs ordered against you. Yeah. Now you get, it's money. It's coming back down to money.
Yeah.
And it also comes down to your share. So whatever it is you haven't disclosed, the other side found, or that you have failed to disclose, the court can carve that out for you. So whatever you think you were trying to hold back on, they'll replace it with the other side stuff. So again, I'm not talking all legalese, but basically there are consequences. Yeah. Consequences are more dire as you go into the process legally, into the court process, into the filing process. And failure to disclose isn't going to give you the options you thought.
Okay. Interesting. I hadn't heard that one before. That's good to know.
Yeah, the whole contravention list, I think, came out, in 2021 in one of the changes.
Right.
But it's designed to be fast and lethal. So whether it's parenting or property, you can get in within 2 weeks, usually 2 or 3 weeks. It's fast.
But then that relies on the lawyers to actually act fast as well. That's...
So the contravention list, you don't have to be represented.
Oh, wow.
You've got your list of all the times your lawyer did this, this, and this, and the other side didn't do. You, as the client, can take your own contraventions list.
Wow.
There's no fee to file in the contravention list.
Why don't more people know about this?
Well, because it also comes down to what is really a contravention.
Uh-huh.
What's
There's always
yeah, there's always that. Was this really something he failed to disclose? And if he didn't disclose it and you couldn't get it through a subpoena, is it really something that matters to the case?
The case, yeah.
And that's another determination outside of the scope of the client. Yeah. So again, you're giving over again. But I guess I really just want folks to understand that you do have full and frank disclosure requirements, just like in family dispute resolution. The consequences are much more dire as far as your property settlement for failure to disclose in the legal setting. And even though you think you've hidden things pretty well, I will guarantee you, if you thought you've hidden it, somebody else knows you have, and somebody else isn't going to go to jail to hide your stuff.
Right. Right. Okay. Yes.
I'm bringing it down to very basic.
Yeah. No, that's fair.
I don't care. Family, besties, mates.
Your accountant.
And there are lawyers, out there, solicitors and barristers. I've learned some very good tricks from barristers on where to find stuff. So just because you think that's the warning. Just because you think you've hidden it, somebody knows you have.
Yes. And so therefore
they're not going to go to jail to protect you. There you go.
Yes.
I think that's
yep. No, that's
we'll wrap up with don't go to jail for friends.
I mean the other thing that I think people don't realise is that the tax department monitors the family court.
They do, bless their heart.
Aren't they gorgeous? Whereas they don't care what I do.
Well, I care that the ATO looks at it too, though.
Yeah.
I mean, especially if I'm the one trying to get the information.
But I mean, in terms of if people want a private process,
it's private.
It's private.
But again, the idea of being the private process is so that people will be more forthcoming.
Yes.
And gives you that breath to be forthcoming without the consequences.
Yes.
So do it. Be forthcoming.
Mm-hmm.
Do it where you can, where it's not going to come back at you.
Yeah. Otherwise.
Exactly. And that's why I think this type of discussion, mediator, lawyer, and let people know there are distinctions.
Yes.
Use the process. Use it to your benefit.
The other concern I have is when they are lawyer, when the FDR is also a lawyer. So when the mediator is also a lawyer, I think the lines get blurred.
I think it can be difficult to keep the lines. I think sometimes it may appear that as a mediator, a lawyer may get a little more push to a client to get to a resolution, knowing that there are some of these things that
I'm thinking more about discovery.
Yeah.
But they will insist on years of.
They insist on the 3 to 5 years of records
and it's a lot for a lot of these people. It's just completely unnecessary and onerous.
I think it's onerous to go through it all too. Let me tell you.
No, well, I do explain to people that
But even if you go through a mediator through the federal court, they do have those requirements. There's another case outline. There's the financial statement. These things have to go, and they have to go slog through all this too.
So that's interesting because as a non-lawyer FDR, I don't have that obligation to ask for all that discovery.
No, but your clients can ask for it again. There's always a trust level.
Yes. Yeah, clients can ask for it.
Yeah.
But it's interesting. So, but if they do mediation within the court itself, they are required to provide.
Again, we have to provide the financial statement and a case outline that outlines all the different aspects. Right. And do you think there's, we know there's money being hidden because this.
So by the time you've got to the court-led FDR,
they've got some evidence.
Yes. Yeah. There's a reason why you've gone down that path. Yes.
But at the same time, use the process where it doesn't come back at you. Is my suggestion. So when they come to you, bring forth all the questions. Bring forth all the if there's a trust issue, let you know right up. But again, at the same time, if you can utilize the process, get over some of these things, and I hate to say get over because sometimes it is about just getting over some of this.
The
realities.
Which is where I find understanding my clients, majority of them have never done this before. They've not been through it a couple of times. Yeah.
Oh, Lord. That's a bit.
So they're dealing with this is all new to them. So understanding that so many people, I especially dare I say young men, will ring up and say, "We've got an agreement. We just need you to help us formalise it." Okay, what's your agreement? And they rattle off something, and I say, "Oh, have you had legal advice around that?" "Oh, no, we're happy with this." Okay, let's sit down and go through what the court requires of you, because you can't just coming up with your own agreement and then submitting it to the court may not satisfy the court's requirements.
There's still you still have to satisfy the court's requirements.
Yeah.
And then again, you can have that discussion. We can look at the documents. I did have somebody recently, and it was just they had, and if you looked at the numbers, it looked 50-50. But nowhere was there her contributions to having the child, staying at home, and still taking and making her share of the mortgage payments, the child care payments.
Oh.
No contribution to super, for over 12 months. And she's like, "Is that a thing?"
Yes, it's a thing. Yes,
so I don't mean to torpedo, but it's a thing. And let's have that chat, and we can manage the conversation to the other side so that he understands that they're, we're talking. Unfortunately, we were talking quite a six-figure difference. So, it became a thing.
Yeah, it would be a thing.
But again, it's up to the lawyers, hopefully, to manage the conversation so that way they understand this is how a court will look at it. Now, if she wanted to give up that amount, she absolutely could, but she'd been notified now.
Yes, now she had the knowledge.
But
do you find the notion that lawyers are required to advocate for the best interest of their client can sometimes get in the way of an
actual agreement?
Yeah. yeah, okay.
More often than not, there are some very zealous folks out there, absolutely. And again, they're getting paid by the hour.
Yeah.
So, it's not, and I think there's a fine line. I do think it gets crossed more often than I would like.
Right.
But at the same time, the zealousness, we are told and taught from the first time you go into law school, you are the zealous advocate.
Yes.
You advocate for your client, you do the best for your client. But what is the best for your client? I think sometimes people put a dollar to that versus understanding the context of the relationship and helping the client move on.
Yeah. That's often,
Yeah. So I think we could use some more seminars and education on that.
Maybe we get them to listen to our podcast.
Maybe they can listen and just have a rethink, but there we go.
The other, I think, important thing around financial settlements and discovery, I think, is the shift in legislation where there is now a threshold where anything under that threshold won't actually end up in front of a judge because the pool isn't large enough.
Yeah, I think it's like 550,000.
Yeah,
they say that their assets. I mean, to me, that's a lot. I mean, to most of us, middle income or less. I mean,
Bayside Melbourne, darling. No.
I've had 9 lives. Yeah. And I remember quite a few of those lives where I'm searching the car and the couch for coins.
Okay, I can relate to another time in my life.
Yeah, exactly.
Yes.
So there is that threshold level, and you have to be cognizant of it. And I think sometimes it really just helps people put a lid on the entitlement and the expectations. You're not going to get $1 million from something that there's only this amount. Yeah, you're not. I think it's just done to narrow down.
What I find, I'm actually dealing with one right at the moment where there will be around about that amount of money, but the one party has now just told me, no, not dealing with you anymore, going to lawyers. Mm-hmm. And I'm thinking to myself,
they're not going to do much different if it's that type of threshold.
Yeah, exactly.
And hopefully that lawyer will tell her that.
Well,
maybe not.
I'm thinking they're following their advice of their lawyer.
To do that.
And look, I get it. Lawyers, especially Sole traders, small business, they're businesses. They're businesses like everybody else, and they've got they've got bottom lines to meet. But it's an $11 billion industry.
It is?
It is an $11 billion industry in this country. So, and of that, only 11% end up with a final hearing. Yeah. Only 5% from memory 8% use the government-funded mediation services.
Yeah.
So that leaves us with about 80% of people
paying
somebody, whether it be a lawyer or a mediator, they're paying somebody.
Yeah.
No, I have to also, I am noticing that there are a lot of people who just come up with their own agreement and walk away.
Good on them. Good on them. I mean,
as long as it doesn't come back and bite you on the bum.
Yeah, which unfortunately a lot of them end up doing. That's when we see them again. It's like, well, we had this binding financial agreement, but then we bought a house, then we had several kids, and then, it's like, well, that changes that quite significantly because you didn't plan for it in that either. Mm. So we can talk about financial agreements as well. But I mean, the more you can agree, the less I'm going to get involved. Mm-hmm. And if you understand the pitfalls, the goods, the negatives, the bads, the uglies. Yep. My job is that you are informed. And if you guys want to do a private agreement and not go to a lawyer and then,
Except it was actually a Facebook group. And this person relayed a story of a friend of his where they had their agreement. They sold the house. They'd been together for, 10 years, whatever it was, sold the house, split it whatever way suited them. She went off and bought herself a nice little house all by herself. 5 years later, he repartners and is made aware that they don't have a formalised agreement. And so he successfully sues, and she had to sell her little house to pay him out because it became part of the pool.
Those things happen.
They do.
That's what I said, more often than not. But at the same time, part of me says, I don't want to get involved if you guys have made that agreement. You don't want a lawyer.
Yeah, fair enough.
But you get what you set up for, unfortunately.
Yeah, but
as much as you don't want that to happen.
Yeah,
I'm sure there are just as many agreements that everybody's okay with.
Yeah, well, that's true. I mean, we could sort of get to the whole gender inequity and
there's so much more than that. I agree. But at this point, we're going to stop on this.
Okay.
And, thank everybody for joining us again.
She's stopping me.
I didn't bring out the whip.
No, you didn't. Thank you. Appreciate that. Thank you so much for today. Been really, I've learned something.
Yeah. Good day.
A good day when you learn something. I love it. I love these conversations. So thank you, everybody, for joining us again.
And we will see you next time.
We will.